Thank you, Your Honor. The interpreter will be disconnecting. Thank you. Bye-bye.
Okay, can I please have Henry Garcia into the courtroom behind the gray podium? Jesse Ross, if you would take a seat in the first chair, and then Eric Hilgendorf, if you would work your way to the second chair, please. All right, good morning, sir. May I please have your name and date of birth?
Henry Garcia, May 4th, 1979.
Thank you very much, Mr. Garcia. And I understand that the county attorney wishes to appear on this matter. May I please have the appearance of counsel for the state?
Brooke Gaunt on behalf of the state.
Good morning, Ms. Gaunt. Thank you for joining us. Okay, Mr. Garcia, you are here on two different matters. The first matter that you're here on is allegations of new charges. The second matter you're here on is an allegation that the new charges violated term 1 of your probation. Ms. Gaunt, is the state appearing on both matters or just one?
Just one, Your Honor.
Okay, we will take them. Okay, we'll take them individually first, and we'll start with the new case. All right, Mr. Garcia, as to the new allegations against you, they are 1 count of murder in the first degree, which is a class 1 felony, 1 count of dangerous drug possession, a class 4 felony, 1 count of possession of a weapon by a prohibited person, also a class 4 felony.
Grab the chair. You all right? You all right? Can you talk to me? No, just grab a chair, put it behind him, because he's following. Sitting you down. You breathing? Garcia? You all right?
You okay, Mr. Garcia?
Garcia?
Yeah.
Can you hear me?
Yeah.
You all right?
Yeah.
You sure? What just happened to you?
I don't know, I just saw white.
Just saw white? Do you know where you're at?
Do I need medical? I'm in court.
You're in court. Do you remember coming into court?
Yes.
All right.
Can we finish?
Mr. Garcia, can you hear me?
Yes.
Do you know that I am a Superior Court Commissioner, and do you understand that we're conducting an initial appearance hearing?
I'm in court.
Okay. You are free to remain seated. If you're more comfortable that way, I don't want to cause any additional medical concerns, so please stay seated right there. If at any point you cannot hear or understand me, please speak up. As I was indicating earlier, you are here on allegations that you've committed new violations. You're also here on an allegation that those new charges violated your probation. The new charges against you are 1 count of murder in the first degree, a class 1 felony, 1 count of dangerous drug possession, a class 4 felony, 1 count of possession of a weapon by a prohibited person, also a class 4 felony, and 1 count of defacing a deadly weapon, a class 6 felony. Based on my review of the factual allegations against you provided to me in a written document by law enforcement called a Form 4, I am inclined to find probable cause to support the murder allegation and the prohibited possessor allegation. I am not inclined to find probable cause at this time to support the dangerous drug allegation or the defacing a deadly weapon allegation. Before I officially make that ruling, though, I would like to hear from the state. Ms. Gaunt, is there any additional argument the state wishes me to consider in regards to probable cause? Ms. Gaunt, it looks like your lips are moving, but we can't hear you. It doesn't look like you're on mute, though. Can you hear the court?
Can you hear me now, Your Honor? Okay.
Yeah,
I
thank you.
apologize. Yes, Your Honor, just briefly in regards to the defacing a deadly weapon charge, there is information in the Form 4 that during the execution of the search warrant and Mr. Garcia's residence, there was a firearm that was found that had been painted all black, which also covered the serial number and defaced that. So I believe, given that information, there is probable cause for that charge as well.
Okay, thank you very much, Ms. Gaunt. I have heard the additional argument. I am declining to find probable cause on that. I understand that that is defaced, that there does appear to be information in the Form 4 that the defendant was in possession of a defaced weapon. I still don't believe there's any factual allegation that the defendant in fact defaced the weapon. So I will find probable cause to support murder and the prohibited possessor allegations. I am not finding probable cause for dangerous drugs and defacing a deadly weapon. Mr. Garcia, my finding of no probable cause on those two allegations does not mean that they're legally dismissed. It is possible that the county attorney's office will file charges on those allegations, but for purposes of this hearing today, I am only considering the murder allegation and the prohibited possessor allegation for determining your preliminary release conditions. You are entitled to a court-appointed lawyer, and I've appointed a public defender to represent you. Your next court hearings will be a status conference October 20th, and then you will have a preliminary hearing October 22nd. They will both be at 8:30 in the Superior Court downtown. As to release conditions on the new allegations, can I please hear argument or recommendation from the state, Ms. Gaunt?
Honor, the state is asking for $1 million cash-only bond, and if Mr. Garcia is able to post that, we'd ask for electronic monitoring. That is based on the serious nature of the allegations. He allegedly shot and killed the victim. He was in possession of multiple firearms, as well as a defaced firearm. He has an extensive violent criminal history with 7 prior felony convictions, including a prior conviction for aggravated assault with a deadly weapon or a dangerous instrument, as well as a disorderly conduct with a weapon. He is currently on probation here in Maricopa County for conspiracy to commit dangerous drugs for sale. We believe that there is a strong weight of the evidence against him. There are 2 witnesses. We are concerned that he's a significant danger to the community. Thank you.
Okay, thank you, Ms. Gaunt. Mr. Garcia, I will give you an opportunity to address the court if you wish to in regards to what release conditions I should consider or impose in this case. Before I do that, I will remind you or tell you, you don't have a lawyer present here to represent you. Your lawyer will be present starting at your next court hearing. You can see and hear that the state's lawyer is here. So anything that you say could be used against you. The state's lawyer will hear it. But you do have the opportunity to provide any information you want me to consider in regards to your release conditions. I would just strongly caution you to avoid talking about the facts of the case because you don't want to say anything that could be used against you. If you want to give me any information to consider, I'm happy to hear that now. You still are free to remain seated, but if you want to provide information, please speak very, very loudly because it's that black bar at the top of the podium that's going to catch your audio. So any information you want me to consider, go ahead and give that to me now.
I have no idea where to begin, and I'm sorry that I don't.
That's fine. You don't have to make any statement. You don't have to say anything if you don't want to, but if you want to, now is your chance.
I know that I want to, I just don't know how.
So what I would suggest then is that maybe you wait to make any statements until your next hearing when you have a lawyer present. You can work through that with your lawyer, and then your lawyer can determine what information to present to the court that is helpful for your case. Okay, in that regard then, I have reviewed the factual allegations in this case. I have reviewed the defendant's criminal history. The state has indicated that Mr. Garcia has 7 prior felony convictions. My review indicates that he has 10 prior felony convictions. Amongst them are dangerous and violent offenses. The defendant is currently on probation in Maricopa County for drug sales allegations. For all of those reasons, I am persuaded that bond is necessary and appropriate to secure public safety. I will impose a $1 million cash-only bond in this case. The second matter that you're here on, Mr. Garcia, is an alleged probation violation as a result of these new charges. I've appointed a lawyer for you in the probation matter as well. Your next hearing in that probation case will be a revocation arraignment. It'll be October 20th at 8:30, so the same date and time as your first hearing on the new charges. On the probation matter, you are not eligible for release on bond. That means you will stay in custody at least until you see the probation court on October 20th. Because of that, I would encourage that you wait until after you see the probation judge before attempting to post your bond on that new case. If you are released from custody after that probation matter, you cannot have contact with any relatives, parents, children of the alleged deceased victim. You cannot have contact with any alleged witnesses of any of the new offenses. You would be prohibited from possessing any weapons, and you would be prohibited from possessing or consuming any alcohol or drugs without a valid prescription if you found yourself out of custody. Anything else I need to address in the new case, Ms. Gaunt? Okay, I didn't hear any audio, but you shook your head no, so I will state for the recording that the answer was no, nothing additional. Mr. Garcia, do you understand the information that we've gone over regarding your release conditions?
Kind of.
Do you have any questions about your release conditions? Is there something that I could make more clear for you?
Not at this time.
Okay. All right. Thank you very much. That will conclude your hearing. If you'll stay right there, these officers will help you work your way back out of the courtroom, and all that information will be given to you in paperwork.
Good. Feeling lightheaded or anything?
Yeah, I got lower back issues too.
Lower back, okay. Oh, all right, feet up.
May I be excused, Your Honor?
Oh, yes, please, Ms. Gaunt. Thank you. All right. Thank you, officers. Okay, Jesse Ross, if you would please work your way into the courtroom. Nikki Bonds, or Nicholas Bonds, if you'd work your way to the second chair. Jesse Ross. I'm going to need some help, it looks like, for this one. No one seems to be moving. I don't think that's Jesse Ross. Can I have your name and date of birth, please?
Yeah, all right. Jesse Ross, 1398.
Thank you, Mr. Ross. You are here on two different matters. The first one is a bench warrant issued when you failed to appear at a status conference in an existing case involving felony trespassing and misdemeanor interference allegations. You have a lawyer already assigned to you in that case. That lawyer will continue to defend you. Your next court hearings in that existing case will be a status conference October 20th and then a preliminary hearing October 22nd. They'll both be at 8:30 in the Superior Court downtown. On that warrant, you have a $1,000 secured appearance bond. The second matter that you're here on is a failure to comply with court terms warrant issued by the Manistee Justice Court. The underlying allegation in that matter is a misdemeanor driving under the influence allegation. You're entitled to a court-appointed lawyer for purposes of release conditions on that misdemeanor warrant. That lawyer will be appointed by the next judge you see at your next court hearing. That hearing will be an arraignment hearing October 15th. It'll be at 10:30 in the Manistee Justice Court. On the misdemeanor warrant, your bond is $50. So your total bond for both matters will be $1,050. It is all secured appearance. If you post that and you are released from custody, you cannot possess any weapons or possess or consume any alcohol